Okay, so let's start. There are a number of responsibilities that come with this Employment Rights Act. And as was mentioned before, it includes issuing contracts of employment. The minister said we had situations where persons come to work and they are not issued with not even a letter. They're given a little pick at some organization. They don't know who the employer is. And you know, in my, as a consultant, helping persons now to become compliant with the Act, you go to companies and you find that they do not even know the date on which people started to work. They don't have that documentation sometimes, and if they do not have information from the National Insurance Department, assuming they pay, then there is no information. They would guess in terms of when this person actually started to work. So that is one good positive thing in relation to what the Act will represent. The particulars of employment, the Minister and Mrs. Bascom mentioned the specifics in terms of that, but let me just summarize again for those of you who would have come late and those you who might not be familiar. The particulars is actually a contract of employment, and it requires you follow the specifics, and you have to, in that particulars of employment, include everything that is that the Act asks for. So if something like a pension scheme does not exist, you still have to mention that the pension scheme does not exist. It's very specific, so you need to follow the guidelines in the specific Act. So you need to include in that contract of employment the title of the job, the description, was mentioned before, the job description, the rate of pay, the methods of calculating the wages, the intervals in which the wages are received, whether it's weekly or monthly, the normal working hours, 8:30 to 4:30, etc. A probation, if there is one. All companies do not give periods of probation, but you must stipulate whether or not this job entitles a person to 3 months probation, 6 months, 9 months, whatever. The required notice period that should be given by the employee, and this is important because in contracts, employers are concerned that employees just up and take off and go on and leave them high and dry. So the Act now makes sure that if you're leaving your place of employment, you give a certain minimum notice to your employer, because he or she has to plan on a daily basis how to operate. And of course, the employer, there is a minimum period which the employer should give notice as well. We also made reference to things like making provision in the contract to indicate whether the contract is fixed term or whether it's temporary. One other important aspect that is contained in the contract has to do with indicating in that contract the location of the business. Where exactly is the place of employment? And that's important because there's some companies, organizations like, for instance, the Transport Board, they have more than one location. So in that contract, you would say that the person may be located at Weymouth, but occasionally they may be asked to work at Spikestown or Oistins or the one other depot, which evades me at the moment. I think there are 3 depots. There's Weymouth, the Mangrove, right? There's also the terminal, there's Spikestown. So there are about 5 or 6 places that person can actually be located. One important area that Tony mentioned has to do with the collective agreement, and like she said, it's not a legally binding document, but now with the inclusion of that in the employment particulars, it becomes binding once it is included in the terms and contract of employment. And you have to say that if there's a contract, if there is a collective agreement, you need to indicate that it is part of the terms and conditions of the employment contract. If you do not say that, and you go to a tribunal or law court, it is not going to be, it cannot be used. So that is the importance of including the collective agreement in the particulars of employment. Then there are other things that you need to include in your contract, which will include things like the holiday period, holiday pay, things like sickness and injuries. Now, there is no law in Barbados that says you have to give an employee 3 weeks sick leave. There's no law. So if there is a practice, and that is what I've been doing with clients, if there is a practice, what we do is to formalize it. But there's nothing that says you have to give anyone sick leave. It's more or less a custom. Reference was made to disciplinary rules, and there is in the Act, there is a schedule, a fourth schedule, which gives some sort of guidelines in terms of the standard disciplinary procedure that should be used in terms of disciplining employees. Also, in that particulars of employment, you need to indicate the person that the employee can go to if they are dissatisfied with any disciplinary decision. Also, because the contract is not a unilateral document, in other words, you cannot make a decision, if you have a contract, one person cannot make a decision that makes it binding. You have got to, if you want to make a change, for instance, if you were working 8:30 to 4:30, and your boss decides, no, I want you to work from 12 o'clock in the night till 6 the next morning, you can't just invoke that just like that. You've got to discuss it with the employee and have an agreement. You can't make unilateral decisions. And in the case then where there is an agreement, then the employer has 30 days in which they submit what is called a change of particulars. So it is formalizing things in ways that was never done before. It will change the way things happen here. There is also the itemized pay statement. Everybody should be familiar with that. Lots of companies do not do that. They just give you a pay packet. They give you money in a little envelopes on Fridays, for those of you who work on Fridays. But there's nothing that companies do. They don't remind you about the gross payment. They don't tell you what the deductions are. And that reminds me of there's a piece of legislation called the Protection of Wages Act, which prevents people from paying. It's very old legislation. Prevents people from paying workers in rum shops. And one can understand why, because somebody can, clear for employer, can take you to a rum shop on Friday evening, and when you get sweet, take out your money, and then say, well, I give you all that money. Of course, you'll be at a disadvantage because you're so tight that there's no way you can remember what actually happened. So the itemized pay statement is important, and it's important that you as an employee ensure that you get that that document which should accompany your wages. Light was mentioned before. Tony also mentioned the progressive disciplinary action, which is new because, I have a client, and again, I don't have all saints for clients. Like Tony don't have all employees that are saints. I've had a couple of employers in the last couple of weeks who has decided that they can, in one case, lay off employees just like that. Of course, I went to the department, and Minister will be pleased with that. They told them to go back to the drawing board. So they came to me, and we went through the whole process to do it in the right way. So the Labour Department is not letting them get away with it. Of course, the concern will be when these things in the next couple of months, when persons are the time period is run out in terms of given the employees' particulars of employment. What will happen? I suspect that you will have a lot of claims because the employees seem to be more familiar with the rights than the employers are, and I suppose that's nothing new. Employees seem to be more familiar with what their rights are than employers. Employer, to prove that an employee was not capable, they really need to have something like a performance appraisal the minister mentioned. There's no other way that will happen, and employers always get themselves in trouble when they go to the union and they say, well, this person is being dismissed because they are not performing. And the union will ask, well, what is the evidence? And very often, there's no evidence. All there is a gut feeling. Somebody sees an employee, they believe, they may have good reason. It is possible that the employee may not be performing, but they do not have it documented. And this happens all the time. I keep telling clients that when an employee violates a regulation or a rule, then you need to document it properly. I had one this last week who employee was cursing in front of customers, cursing another employee in front of customers, and the employer did nothing. All it is told me, look, Peter, I have to get rid of this person. And I asked them, why didn't they not take action? But of course, sometimes some of them are afraid of taking some action as well. So I said there were 4 reasons, fair reasons. The first one has to do with the capability. That's one has to do with the conduct of the employee. Then redundancy that was mentioned earlier. And then finally the inability of the employee to continue working because the position which they hold on their part, on the part of the employer, is in contravention of a duty. For instance, if you have a bus driver and the bus driver is license is taken away for some violation or something like that, then obviously that driver can no longer work, and so that refers to that incident. Okay, so ladies and gentlemen, I've summarized for you what the minister and what Mrs. Bascom mentioned, and I hope that I will leave obviously my segment is available on PowerPoint, so the past is free to share it with anyone who wishes to make reference to it. Okay, so thank you very much.